Now to Virginia, where voters are set to consider pro-life and pro-family measures in the midterms this November. One measure would enshrine the so-called fundamental right to abortion in the state constitution. If passed, the amendment might jeopardize existing laws protecting unborn children in the Old Dominion. It might also endanger Virginia's parental notification law. Virginia protects life after 28 weeks of pregnancy, meaning abortion is legal until the end of the second trimester. It is also legal after that if the mother's health or life are at risk. Church leaders recently unveiled the Catholics Vote No campaign, which seeks to have the faithful vote against both the abortion measure and one that would repeal the state's definition of marriage as being between one man and one woman. We recently spoke with a legal expert on these ballot initiatives. More, we turn to Lorna Henry, attorney at the Pro-Life Pacific Justice Institute. Lorna, thank you so much for joining us. There's a lot to unpack, including a major case involving parents' rights in California. But first, let's turn to the midterm elections in Virginia. Can you tell us more about the push to add abortion to the state constitution?
Yes, this is a trend we are seeing since 2022 with the overturning of Roe versus Wade by the U.S. Supreme Court. States have tried to increase abortion access through constitutional amendments, and the Virginia legislature has done just that. I live in Maryland, and Maryland passed a constitutional amendment giving greater access to abortion in 2024. Now, Virginia is doing it this year. One of the most concerning parts of this, and there's multiple aspects of it that are very concerning, is that the language states that every individual has a fundamental right to reproductive freedom, and that would include minors. So the question is, what happens to parental rights notification and consent laws in this state? So, and the answer appears to be it would essentially invalidate it. So this is a big issue. It's a trend across the country. Nearly a dozen states have passed such constitutional amendments. So it's something that very much be on the lookout for.
Thank you, and thanks for raising that concern about parental rights. As we mentioned, in November, Virginians will also consider a measure on same-sex marriage. Lorna, can you take us through what this proposal says?
Sure. So Virginia had a constitutional amendment before the 2015 Obergefell v. Hodges decision by the U.S. Supreme Court, which required states to recognize same-sex marriage. Before that decision in 2015, Virginia had a constitutional amendment stating that marriage is between one man and one woman. Well, since the Supreme Court issued a ruling requiring same-sex marriage, that amendment was unenforceable. But Virginia wants to pass another amendment basically stating that marriage is between or there is no discrimination in marriage, their words, based on sex, race, and another, what they consider protected class. The reason this is concerning is because it conflicts with the religious beliefs of organizations and churches or schools, and we don't know whether or not it would be more difficult to challenge the rights of people of faith once this same-sex marriage recognition is made enshrined in their constitution.
And now to the courtroom. We know you follow many important cases, including Mirabelli versus Bonta in California. This involved a school policy that conceals students' so-called gender transition information from their parents. Can you remind us again what this case says and how recent rulings have gone?
Yes, so Mirabelli v. Bonta involves a California school policy that requires schools to conceal from parents whether or not their child is having gender identity issues. And interestingly, this law was challenged by not just parents, but teachers. And so the Supreme Court referenced an earlier decision last year, Mahmoud v. Taylor, which didn't deal with gender identity notification. It dealt with whether or not parents can get notice and opt-out rights if they believe that the curriculum conflicts with the religious upbringing of their child. And so the court is extending the decision from last year to say parents are the ultimate authority when it comes to raising their children. And it is likely that the parents will win in court in this Mirabelli decision. So this is handing control back over to the parents and taking it away from the states.
That's great. Now, we know you also followed the case regarding pro-life pregnancy resource centers and the state of New Jersey. Can you take us through the Supreme Court ruling in favor of pro-lifers? And do you think this could have an impact on other pregnancy resource centers?
Oh, absolutely. So there is this major case in New Jersey, First Choice Women's Center. This is against their attorney general, and it's really unprecedented. The attorney general attacked this pro-life faith-based pregnancy center for no reason at all. It requested a massive amount of documents, personal information like the names and addresses and employment data of their donors, in an attempt, it appears, to intimidate them from expressing their pro-life views. And the Supreme Court said that a government and attorney generals cannot do this. Basically it said that the Pro-Life Resource Center can challenge the subpoena. That was the issue. That was the issue, whether or not they could challenge the subpoena, and the Supreme Court said yes. Governments should not be able to intimidate pro-life resource centers, and this has huge implications for pregnancy centers all across the country.
Now, before we let you go, is there anything else you're following that we should be aware of?
Well, in Maryland, a lot is going on in the area of abortion, which is what we see all across the country. And we also see that in Massachusetts, how states are treating late-term abortions, and also how they are trying to increase access to abortions and contraceptions on college campuses. Parents send their kids to school to get an education, not to have the government infringe on what the parents should be doing and helping their children with. So this area of abortion is very broad, very wide, and we're going to see a lot of it, a lot of challenges in the days to come.
Well, Lorna, thank you so much for the work that you're doing and for explaining everything to us so succinctly.
You're welcome. Thank you.